The committee will come to order. At the conclusion of opening statements yesterday, the chair called up the discussion draft promoting new Manufacturing Act, and the bill was open for amendment at any point. Are there any bipartisan amendments to the bill? Seeing none, are there any other amendments? Mr. Chair recognizes the gentleman from Texas, Mr. Barton.
Mr. Chairman, I have an amendment at the desk. Barton 01, I think.
Clerk will report.
Amendment to the discussion draft, the Promoting New Manufacturing Act, offered by Mr. Barton of Texas.
Mr. Chairman, I would ask the amendment be considered as read.
Without objection, so ordered. And we will distribute the amendments, and the gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I don't think it'll take 5 minutes. The bill that's been introduced by Mr. Scalise that we're marking up today was sent to the Environmental Protection Agency for their comments, and they have commented on it. They sent back a number of concerns. So the amendment that I've just introduced is an attempt to address those concerns. One of the primary issues that the EPA raised relates to the so-called dashboard in the bill. EPA expressed concern that the agency would have to collect significant additional information from state and local authorities in order to provide data for the permitting dashboard. The amendment before us, Mr. Chairman, would clarify that for the dashboard, EPA should provide the agency's estimates of the number and timeliness of permits issued and should base those estimates on information currently in possession of the agency. It would make clear that the agency is not required to seek additional information from state and local agencies. EPA also had a concern that the agency would not seek additional information from states and local permitting authorities in order to prepare the annual report for the Congress that's required under the bill. This amendment makes clear that the report should describe actions being taken by the EPA to expedite the permitting process and that there is not a need to collect additional information from the state and local permitting agencies beyond what the agencies have already provided voluntarily to the EPA. A final concern is that the EPA had concerned the section of the bill that provides if the agency establishes a new national ambient air quality standard or revises an existing standard, the agency should also publish implementing regulations and guidance at the same time. My amendment provides flexibility to EPA by providing that EPA must issue concurrent regulations and guidance, and I quote from the amendment, as the administrator determines necessary and appropriate to assist states, permitting authorities, and permit applicants, end quote. This should address concerns that were raised at the hearing last week and by the EPA that the agency would be required to issue regulations or guidance that was not needed. There are billions of dollars, Mr. Chairman, of investment pending. Manufacturers need to know the rules of the road in order to get these facilities permitted. My amendment would ensure that these projects become a reality, but it also protects air quality and the public health. I would hope that on a bipartisan basis we could endorse this amendment. And with that, I would yield back, Mr. Chairman.
Gentleman yields back his time. Chair recognized for a purpose. Gentleman from California.
Strike the last word.
Gentleman is recognized for 5 minutes.
This amendment makes some modest improvements to the bill. It's a step in the right direction, and I won't oppose it. Unfortunately, this amendment fails to fix the most significant problem with the bill. The bill still creates a loophole in the Clean Air Act, allowing new facilities to emit more pollution and harm public health. I want to discuss two of the changes made by the amendment. As drafted, the bill requires EPA to compile 6 years of historical data on pre-construction permits issued across the country and calculate how many permits were issued within 1 year. At the subcommittee hearing, the Delaware Secretary of Natural Resources raised concerns about the burden this would place on state and local permitting agencies, which would have to collect this information for EPA. The amendment before us provides that EPA does not have to collect data from the states and can just use the data it already has. EPA currently maintains an online database to share information about air pollution control technologies used in permitting decisions. State and local permitting agencies report permit information to EPA on a voluntary basis. EPA estimates that the database reflects only about half the permits issued. The new language certainly reduces the burdens on states, and I support the change. That said, with this change, it's not clear that the bill's new permitting database, this bill serves any purpose at all. The new database would use the information from the existing database to calculate statistics about permitting times, but these statistics won't be valid because it would be based on a partial and non-representative sample of permits. In fact, the database is likely to systematically overstate permitting times. That's because states are most likely to report the most significant permits, which are often more complex and time-consuming. Now, why would we require EPA to report information that is almost certainly misleading? This is a waste of ever-shrinking EPA resources. The amendment makes another change. As drafted, the bill requires EPA to issue implementation rules and guidance at the same time it revises air quality standards. The amendment qualifies this by providing that EPA shall issue rules and guidance concurrently, but only, quote, as the administrator determines necessary and appropriate to assist states, permitting authorities, and permit applicants, end quote. So on the one hand, the amendment provides a helpful change. EPA's technical assistants and witnesses at the subcommittee hearing pointed out that it isn't always necessary or advisable to issue guidance and rules concurrently with a new air quality standard. The amendment gives EPA some discretion to determine when such rules and guidance are appropriate. But the amendment leaves subsection 3B of the bill intact. Subsection 3B states that if EPA fails to publish final regulations and guidance concurrently with a new air quality standard, then new facilities can receive pre-construction permits under the old air quality standard rather than the new one. They have amnesty from the new science-based health standard. This makes no sense. The amended bill would recognize that concurrent rules and guidance aren't always appropriate, but it would still block a new air quality standard from applying to permits unless and until EPA issues such rules and guidance. If EPA wants a standard that protects public health to go into effect, the agency really doesn't have a choice at all about issuing the rules and guidance. Worse, facilities can get out of meeting the new standard by claiming EPA's guidance is insufficient. And this is still a big and harmful loophole. Again, I won't oppose this amendment, but it fails to address my core concerns with the bill. Yield back my time.
Gentleman yields back his time. Is anyone else seeking time on this amendment? Seeing none, a vote will be called on the amendment offered by the gentleman from Texas, Mr. Barton. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The ayes have it. The amendment is agreed to. For what purpose the gentleman from California seek recognition?
Mr. Chairman, I have an amendment at the desk. It's Waxman 02.
The clerk will report the amendment.
Amendment to the discussion draft offered by Mr. Waxman of California.
Gentleman is recognized for 5 minutes in support of his amendment.
Mr. Chairman, this is a simple, targeted amendment that strikes subsection 3B of the bill. Subsection 3B bars a new national ambient air quality from being applied to a pre-construction permit until EPA publishes final regulations and guidance for implementing the new air quality standard. This goes to the very heart of our objections to the bill. My amendment won't fix all of the problems with this bill, but it will address my greatest concern, that the bill allows more dangerous air pollution to be emitted. Under this bill, if EPA does not issue rules and guidance governing implementation at the same time as it finalizes a new air quality standard, polluters would receive permits based on the old air quality standard that is inadequate to protect public health. In effect, it provides new polluters amnesty from new air quality standard. The majority has offered an amendment that addresses some of these concerns about the bill raised at the hearing. Unfortunately, the amendment we just adopted does not change this amnesty provision. Under the amended bill, EPA would have discretion as to whether or not to issue rules and guidance at the same time as it issued a new air quality standard. But if EPA chose not to issue that guidance, the old standard would apply for permitting purposes. In fact, if EPA decided that existing implementation regulations were sufficient for the new air quality standard, under this bill, the new sources would never have to meet the new standard for permitting purposes. This is both nonsensical and harmful. At the legislative hearing on this bill, we heard from Colin O'Mara, Secretary of Natural Resources for the state of Delaware. Secretary O'Mara stated that this provision, quote, would likely cause substantial adverse health impacts by exempting sources from complying with health-based air quality standards, end quote. Well, in short, this amnesty provision would allow new sources to pollute more and air quality and public health would suffer. This provision would have other troubling effects as well. In an area that doesn't meet the air quality standards, if one source emits more pollution, other sources will eventually have to pick up the slack and control more. So by granting amnesty to new sources, the bill shifts pollution control responsibility and costs to existing sources. This shift will raise pollution control costs overall. As the Clean Air Act has long recognized, it's generally far more efficient and cost-effective to build pollution controls into a facility up front rather than adding them later. But this provision does the opposite. It is also unclear what EPA would have to do to avoid triggering the amnesty provision. The bill does not explain what kind of implementation rules and guidance are required or what would be sufficient to satisfy the requirement. EPA could issue a rule and someone could challenge it as inadequate. Depending on state actions during the litigation and the outcome of the litigation, final permits issued in the interim might be invalid or subject to further legal challenges. This uncertainty and confusion will only further complicate and delay permitting efforts. The amnesty provision in Section 3B harms public health, threatens existing industrial facilities, adds regulatory uncertainty, and likely delays permitting. That's a lose-lose proposition all around. So I urge my colleagues to support this amendment to delete the amnesty provision. And since I have a little bit more time, let me talk about this in more general terms. We have air quality standards that are set by EPA. These standards are based on to protect public health. And we learn more, and therefore often these standards are made more perfected by virtue of the knowledge that we have, the science as we later determine it. Well, if we allow a new source to come in that pollutes more than would be permitted for them to go into operation, then we're going to have an area that's going to be exceeding the health quality standards. And so they're going to have to look for ways to reduce that extra pollution. Well, if they're not going to reduce the pollution from a new source, they're going to have to go to existing sources. Wait till you hear from the businesses that are going to be affected. They did the best they could, and if we impose upon them the extra burden, they're going to have to spend a lot more money to accomplish it, and it just doesn't make sense. It's contrary to the way the Clean Air Act has always worked. So I urge support for the amendment.
Gentleman's time has expired. Who seeks recognition?
Chairman.
What for what purpose? Gentleman from Louisiana, rise.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
And first, I object to the amendment, but want to point out, first of all, that there's no amnesty in the bill. In fact, existing law and the existing standards would already have to be complied with. If you look at the section that my friend from California is trying to strike, he's trying to gut the bill and take away the accountability. All we're doing is telling the EPA, if they've got some new proposal, if they want to implement a new standard, they've got to give the guidance to go along with it. Because what we've seen from the EPA too often is using, under the guise of a new standard, it's really just an attempt in a de facto way to deny permits to people. In fact, a lot of these manufacturers are going to be not only creating jobs and manufacturing products in America, but they're going to be doing it with the best environmental technologies that are available in the world. Because if they don't do it here, they're going to be going to other countries. In fact, many are going to other countries because of the EPA's attack on American manufacturing. They're going to countries where they don't have the level of standards that we enjoy today, which are very high standards. And I'll point out to the gentleman from California, I know he's concerned about the EPA's meager existence. They're barely scraping by to make ends meet. They've got nearly 17,000 employees at the EPA, nearly 17,000 employees, and yet they can't give basic guidance. If they're going to come out with a new standard, they ought to be able to back it up with the science, with the data, to tell people how to comply. Now, if they don't want to put out a standard that people can comply with, which, by the way, they've actually done a number of times, that's not their role. Their mission is not to shut people down and deny jobs in America. If their job really is focused on trying to increase air standards, and they've got great science to show a new standard is going to help do that, then put the data out there. Give the guidance. We had testimony last week at our hearing on this, and in fact, one of our witnesses was a permitting engineer. He testified, "What I would like to know is, what do you want me to do to make the demonstration? And right now, in a lot of cases, that guidance doesn't exist." Close quote. Mr. Barton's amendment gives the administrator some greater flexibility to work with the states. So that's already been put into the bill. In fact, Dr. Cassidy's got another amendment that's going to be coming up shortly that clarifies that a new facility must install the best available control technology. So at some point in time, if businesses are going to have all these requirements dumped on top of them, there is a responsibility that the agency has with some real disclosure that they've got to show people how they can implement it. Because if it's not implementable, then clearly it goes to prove the point that we hear too often, is that EPA is just trying to put standards out there that they know are not achievable because they just want to deny people permits. If they've got a standard that they really think is going to help improve quality, then put the data out there, be transparent about it, and give the basic guidance. Just give the basic guidance when you put out the standard. It's not asking too much of their nearly 17,000 employees. And, you know, maybe if they don't have the time, maybe they got to get more efficient about what they do in their regular job instead of trying to put people out of business. They ought to be figuring out how to actually do the things that they're actually out there touting. If they want to increase air quality, then back it up with the science. Be transparent about it and give the proper guidance to show that it can be done. And if they can't, then clearly the proposal's not serious. And it shouldn't be brought forward in the first place because it's not about increasing air quality. It's about running jobs out of this country. And that's not what the role of a federal agency should be, especially the EPA, which has such a horrible track record in this area. So with that, I object to the amendment. I want to have the higher standards that we put in our bill with the increased transparency that actually makes the EPA back up the things that they're proposing with real guidance. With that, I yield back the balance of my time.
Gentleman yields back his time. Anyone else seeking? Gentleman from New York, recognized for 5 minutes.
Thank you, Mr. Chair, and move to strike the last word.
Gentleman is recognized.
I support my colleague's amendment. If experience has taught us anything over the past 2 decades, it is that the Clean Air Act has been a success. New businesses have started, the economy has grown, and the air is cleaner and healthier for all of us. The adjustments to the National Ambient Air Quality Standards that EPA institutes are supported by a large body of research on the impacts of air pollutants on human health and on the environment. The proposed legislation assumes we cannot continue that record of success. The bill also sets up a new process that may benefit a new project, but that benefit comes at the expense of existing businesses and activities. States develop comprehensive implementation plans. Remember, the states approve these permits. Those plans take account of all possible pollution sources and balance the need of all stakeholders in the effort to achieve cleaner air. Section 3B of the bill would allow a new facility to operate under less strict air quality standards than existing facilities if EPA has not issued all final regulations and guidance required for any type of facility that would be covered by a newly established standard. It seems to me that removes flexibility. Guidance is useful for the regulated community. As new situations are encountered, the agency can work with an applicant to find the most appropriate and cost-effective means for moving their project forward under the law. It seems to me that we want to simplify the regulatory process, not complicate it. We should ensure that regulations are implemented fairly and consistently, and we should facilitate and encourage the agency to work with regulated entities. If the agency would call a standard into question by issuing guidance at a time after a regulation is finalized, why would the agency ever do that? I think this is going to result in greater confusion, more legal challenges, and certainly a less flexible regulatory process. I don't see how the lack of guidance helps an applicant to comply with the law and move forward with its project. Our ranking member is offering an amendment to improve this bill, and I hope it would be accepted. I have some time remaining. Is it okay? With that, I yield back.
Gentleman yields back his time. Anyone else seeking time in support or in opposition of this amendment? Gentleman recognizes the lady from California.
Thank you. Thank you very much.
For 5 minutes.
I move to strike the last word.
Lady is recognized.
Thank you. I support my colleague's amendment. This bill is based on a false premise. The bill assumes that weakening the Clean Air Act will push EPA and state and local agencies to issue pre-construction permits faster. That's a baseless assumption and one that could have serious implications for public health. Under current law, a company wanting to build a new facility or expand an existing one must obtain a pre-construction permit. The goal of this permitting process is simple: to ensure that the facility will not significantly increase air pollution above levels that are safe to breathe. The bill creates a new loophole in the law that could undermine this simple goal. If EPA issues a new or revised national ambient air quality standard, the bill provides that the new standard doesn't apply for permitting unless and until EPA has issued implementation rules and guidance for the new standard. I appreciate Mr. Barton's amendment to give EPA more discretion as to whether to issue implementation rules and guidance concurrently with new air quality standard. But this isn't a real choice. Unless and until EPA issues the rules and guidance, the bill allows new sources to violate the new air quality standard but still receive pre-construction permits. The result will be harmful levels of pollution. Delaware Secretary of Natural Resources testified that concurrent guidance isn't always practical or necessary. EPA told the committee the same, that most guidance evolves after the standard takes effect as states and industry raise questions that require EPA guidance. It's unclear how EPA could provide guidance on solving problems before those problems even arise. The bill sets EPA up to fail. On the one hand, EPA could hurry to issue guidance before hearing concerns from states and industry, but then that guidance will be incomplete. An industry group that wants to delay implementation of the new air quality standard need only file a lawsuit saying that EPA's guidance wasn't sufficient. On the other hand, EPA could wait to issue more robust and helpful guidance, but in the meantime, facilities would be able to obtain permits under the old air quality standard. A company could build a facility that is allowed to pollute more than it would under current law. That's an opportunity for even more lawsuits and delay. Downwind communities likely would not be pleased to learn that a facility is being allowed to pollute more. Nearby facilities likely would not be pleased to learn that they may have to cut their emissions more in order to make up for new facilities' extra pollution. All said, this bill amounts to more litigation, more confusion, and more pollution. I do not see how any of it amounts to faster permitting. Mr. Waxman's amendment would strike the language in the bill that exempts facilities from complying with newly issued or revised air quality standards. I urge my colleagues to support this amendment. In closing, I want to note that this bill does what this bill does not do. It does not provide one penny more to EPA for the state and local permitting agencies to hire more staff to review and process permits. That's what these agencies need. They don't need more loopholes. They don't need more lectures about so-called red tape. They need more funding. These agencies have seen their budgets cut over and over again in recent years. I do not understand how my colleagues on the other side expect EPA and the state and local permitting agencies to do more work more quickly with fewer resources. It's just not realistic.
The gentlelady yield.
Yes, I'll yield to the ranking member.
Thank you. I just want to very briefly rebut the statement made by our colleague from Louisiana. The EPA sets the standards. The EPA may offer some guidance how to meet those standards. But the EPA does not give the permits. The permits are issued at the state level. And if EPA sets a standard and has not provided the guidance, that doesn't stop the permits from being granted. They still may be granted by the states. The problem with this bill is that if they set a standard more protective of public health, and we then say that the new permit applicant doesn't have to do what's necessary to meet the new standard but rely on the old standard, that means they're going to pollute more than they otherwise would. And what this legislation would accomplish is to allow them to try to hook onto the old standard and continue to pollute more than would be necessary with the new air quality standard. So we're trying to correct this problem. Thank you for your.
Gentlelady's time expired. Anyone else seek recognition? I'll recognize myself for just a few minutes. This debate is about trying to marry up the rule with the guidance sooner so that there's less uncertainty in those people who have to comply. Where the ranking member is correct on the permitting, the question is on how do you model that, and where's the guidelines by the EPA for the states to develop a modeling system which they can comply with. And, you know, ozone is a perfect example. A rule came out 2008. The regulations, the guidance came out 5 years later. There's tremendous uncertainty, and now we may be going to a new ozone standard just down the path. So this tries to create, this is more of a process debate than anything. And so that's why I respectfully ask a no vote on the Waxman amendment and support my colleague, Mr. Scalise, and I yield back my time. Anyone else seeking time? If not, the vote will occur on the Waxman amendment. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the noes have it. The noes have it. The amendment's not agreed to. Is there anyone else seeking? Chair recognizes the gentleman from Louisiana, Dr. Cassidy.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the discussion draft offered by Mr. Cassidy of Louisiana.
And Dr. Cassidy is recognized in 5 minutes in support of his amendment.
Yeah, the purpose of this bill is to cut red tape and ensure modern manufacturing facilities can be built in the U.S. We heard testimony last week. There's an estimated $112 billion in new manufacturing projects related to abundant natural gas supplies that have been announced. In fact, just to give a context, the Wall Street Journal noted yesterday Louisiana is becoming the cutter on the bayou. Companies are building fertilizer plants, large liquefaction facilities, methanol terminals, polymer plants, ammonia factories, and paper finishing facilities. 66 industrial projects announced worth some $90 billion breaking ground over the next 5 years. Translate into tens of thousands of jobs for Americans who are currently struggling. Now, we've also heard, however, about the challenges manufacturers face in obtaining necessary pre-construction permits under the Clean Air Act. There was testimony about how permitting delays can derail projects and how it can take more than a year or potentially years to get a decision on an application. Now, one of the major challenges manufacturers face is that regulatory requirements can change while a permit application is pending, including changes to the National Ambient Air Quality Standards, and the new standards become effective immediately for permitting purposes. At the same time, EPA frequently fails to issue implementing regulations and guidance for months or even years. Under the bill, there are common sense provisions that require that if EPA establishes a new ambient air quality standard or revises an existing standard, EPA should publish implementing regulations and guidance at the same time. The bill would provide that the new standards would not take effect for permitting purposes until the regulations and guidance was issued. Now, we heard assertions last week at the legislative hearing that requiring EPA to issue timely directions to permit applicants could lead to loopholes or amnesty for permit applicants if EPA was slow in developing its regulations and guidance. The implication was that permit applicants could avoid installing state-of-the-art emissions control equipment. This is not the intent of the bill. My amendment clarifies that under the bill, new manufacturing facilities must install the best available emissions control technologies. In particular, this amendment makes clear that, 1, nothing in the bill changes the obligation of new facilities in areas that are in attainment with national ambient air quality standards to install the best available control technology to address emissions. Further, number 2, nothing in the bill changes the obligation of new facilities in areas that are not in attainment with such standards to install the lowest available emissions rate technology to improve air quality. My amendment would make explicit that nothing in the bill eliminates the requirement that new manufacturing facilities install the best available emissions control equipment. We want modern, new, clean manufacturing facilities to be built in this country. This bill is intended to make sure that this happens even as air quality and public health is fully protected. I urge support of my amendment. I yield back.
Gentleman yields back his time. Anyone? Gentleman from Kentucky.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment is not objectionable, but it doesn't actually fix the bill's core problems. Section 3B of the bill gives new sources amnesty from compliance with the new or revised air quality standard until EPA issues rules and guidance on implementation of the air quality standard. This amendment doesn't affect this requirement in any way. All this amendment does is reiterate that this bill doesn't affect the Clean Air Act requirement for new sources to install some pollution control technology. That's fine as far as it goes, but it doesn't address our concerns with Section 3B. When a company applies for a pre-construction permit to build a new facility or modify an existing one, there are 2 steps. In Step 1, the company must determine which pollution controls it will install to reduce the facility's emissions. The bill does not appear to affect this obligation to identify effective pollution controls. This amendment reiterates that the obligation remains. In Step 2, the applicant must estimate how much pollution the new source will emit after installing pollution controls and show that it will not cause a violation of the air quality standard. In other words, the applicant must model air pollution in the area and show that adding pollution won't make the air unsafe to breathe. If the new facility's emissions will cause a violation of the air quality standard, the applicant must take additional steps to cut its emissions or obtain offsets for the excess pollution. The bill interferes with this second step of the process. EPA revises national ambient air quality standards when the science says it is necessary to protect human health. EPA may not make a national ambient air quality standard more stringent unless it finds that the old standard was not sufficient to protect the public health with an adequate margin of safety. But the discussion draft allows facilities to disregard a new air quality standard. If EPA doesn't issue rules and guidance at the same time it issues a new air quality standard, the old air quality standard applies for purposes of a pre-construction permit. This means that when the facility is demonstrating whether its emissions will violate the air quality standard, it is using the old insufficiently protective standard as a benchmark. In practical terms, this will allow some facilities to emit extra pollution at levels that could harm public health. Under current law, facilities that would violate the new air quality standard would have been required to take extra steps to reduce their emissions and protect local air quality. Unfortunately, this amendment does nothing to close the loophole created by the bill in the second step of the permitting process. And it's during the second step that the facility has to prove that its pollution won't harm public health. I don't object to the amendment as it doesn't make the bill worse, but I urge my colleagues to oppose the bill even if the amendment is adopted.
Gentleman yields back.
Yield back.
Gentleman yields back his time. Anyone else wishing to speak on the amendment? If not, we'll call the question on the amendment offered by the gentleman from Louisiana. All those in favor say aye. All those opposed say no. In the opinion of the chair, the ayes have it. The ayes have it. The amendment is agreed to. A lot of excitement here this morning. Anyone else seeking recognition? Chair recognizes the gentleman from California.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the discussion draft offered by Mr. McNerney of California.
Gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. Mr. Waxman laid out a very clear case for why we should strike Section 3B from the bill. It creates a loophole in the Clean Air Act that allows new facilities to meet old air quality standards, which is a form of amnesty. Unfortunately, the committee chose to reject Mr. Waxman's amendment. If the committee is unwilling to remove the Section 3B amnesty loophole from the bill in the pretext of expediting the permitting process, then we should at the very least, give state and local permitting authorities the opportunity to do so. That's what my amendment does. At the subcommittee hearing, Colin O'Mara, the Secretary of the State of Delaware, the State Department of Natural Resources, stated in no uncertain terms that creating a new Clean Air Act amnesty loophole will do nothing to expedite air permitting in his state. Nothing. But implementing this amnesty loophole could have serious consequences. Secretary O'Mara warned that the bill could harm public health by exempting new and expanding facilities from complying with science-based air quality standards. This means more pollution will enter the air and it will be harder to clean up. Secretary O'Mara warned that the bill could harm existing businesses. When one facility is allowed to pollute more, other facilities in the area will have to invest more to reduce their emissions. That's not fair and it's not good for the economy. Secretary O'Mara warned that the bill could increase the cost of achieving air quality standards. It's much cheaper and more efficient to install pollution controls at the front end when a facility is being constructed rather than after operations begin. This bill gets it backwards. More facilities may have to install expensive retrofits in the future to make up for letting new facilities off the hook now. Secretary O'Mara testified that regulatory certainty and predictability are important factors in corporate decisions to build or expand facilities in his state. But he warned that the bill would increase regulatory uncertainty for industry by setting up new avenues for litigation and delay. Secretary O'Mara articulated many valid concerns about how this bill could affect his state. He should not have to opt out. He should not have to adopt a program that he thinks will be counterproductive and harm human health. No state or local permitting agency should be forced into that situation. My amendment simply says if a state, federal, local, or tribal agency determines that adopting this loophole will increase air pollution that harms human health, slows issues of permits, increases regulatory uncertainty, creates new litigation, shift the burden of pollution control to small businesses and other existing facilities, or increase the cost of achieving breathable air, then the agency can opt out. The agency does not have to issue a permit that exempts a new facility from meeting protective air quality standards. This amendment does not fix all the problems created by this bill, but at least it would allow the state and localities to avoid some of them. I urge my colleagues to support this amendment. Yield back.
Gentleman yields back his time. The chair recognizes himself in opposition to the amendment. Obviously, Section 3B is a critical part of this bill. Permit applicants, actually those people who have to comply, should not be left in the dark on how to comply with new permitting requirements. That's the whole reason why we're having the bill, so that there's more certainty. And in part of the discussion of my friend from California is we would concur that you want to do the emission standard right when you're building the new facility, so you should know the requirements. If a new rule gets put into place, the EPA should be able to help assist and say, well, how do you do that? And that's kind of, I think that's where the two sides are kind of disagreeing with it. That's why we believe it's a process debate. It's entirely within EPA's control to issue direction to permit applications when it sets new standards. The amendment offered by Mr. Barton provides additional flexibility to the agency in issuing such guidance. I want to remind my friends, EPA can and should get their job done on time. In the previous comments, I talked about the ozone standard and the 5 years. Also, another reason why we permit applicants need to know the rules of the road. EPA ultimately has a veto authority over the states on permitting, and the states need to know how EPA views how they're going to comply with these issues. So with that, I would ask my colleagues to vote against the amendment, and I would yield back my time. Anyone else seeking time? Gentleman from New York is recognized.
Thank you, Mr. Chair. I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I support Mr. McNerney's amendment. It wouldn't solve all of the problems with the bill, but it partially addresses one major concern. Section 3 of the bill requires EPA to issue implementation regulations and guidance at the same time it issues a new national ambient air quality standard. That requirement is problematic for a number of reasons, but the bill doesn't stop there. Under Section 3B, until EPA issues the required regulations and guidance, new sources of pollution get amnesty. They don't have to meet the new, more protective air quality standard in order to get a pre-construction permit. This creates a big loophole in the Clean Air Act that could allow new facilities to emit more pollution than is safe. Not only does this provision threaten public health, it is also unfair to existing facilities. In an area with unhealthy air, we all know that pollution is a zero-sum game. If new facilities are allowed to emit more, existing facilities will have to emit less to make up for that extra pollution. And it's generally much more expensive to add pollution controls to existing sources than to build in controls up front when you're designing and building a new facility. This just doesn't make any sense. How would shifting pollution control burdens to existing manufacturing facilities and raising pollution control costs overall boost American manufacturing? Although this bill focuses on state permitting, at the legislative hearing that we recently had, we heard from only one state permitting official, that being the Delaware Secretary for Environment and Energy. Secretary O'Mara explained that allowing new facilities to get a pre-construction permit under an outdated air quality standard will produce confusion and uncertainty. EPA echoed this concern in its technical assistance to the committee. The result would be more litigation and more permitting delays, which wouldn't help anyone. The stated purpose of this bill is to speed up permitting. Well, if a state, local, or federal permitting agency decides that this amnesty provision would actually slow down permitting, it should not be bound by the provision. If a state finds that allowing facilities to be permitted under an older air quality standard would harm public health, a state should be able to opt out of this provision and protect the health of its citizens. If a state finds that the bill's amnesty provision would create regulatory uncertainty and indeed increase litigation, a state should not be required to implement it. That's all Mr. McNerney's amendment does. The amendment allows each permitting agency to make its own decision about whether this amnesty provision would assist or impede its permitting. We often hear from our Republican colleagues that we should leave more decisions to states, more decisions to localities. Well, here's our chance. Here's your chance. You can vote for the McNerney amendment and allow states and localities to make the final decision on whether this flawed provision would help or would hinder their permitting efforts. I urge everyone to support this common sense amendment.
Gentlemen, yield if you have time.
And I will yield my remaining time to our ranker, Mr. Waxman.
Thank you very much. Look, the EPA sets the standard. They learn more from the science as to what the standard ought to be to protect public health. So they set a new standard that's more stringent than the previous standard. At the state level, for the most part, an applicant will come in and ask for a permit to build a new facility. The state, generally, it's usually the state, would then say, we want you to do the following in order to get your permit. You've got to reduce the amount of pollution to a greater extent. If we don't adopt the McNerney Amendment, that state won't be able to make the decision. You take away the power of the state to make the decision. Well, the whole idea of the Clean Air Act is the federal government sets the standards, but it leaves the states with flexibility to decide how to meet the standards. And the state now, if they chose to, not they don't have to, but if they chose to, under the circumstances outlined in this amendment, they could say you can go ahead with a permit, but you've got to reduce the pollution more because we don't want to make other sources have to reduce that pollution for the whole region, because it's not a fair burden to place on existing sources if a new source can use existing technology to achieve a lower amount of pollution. And this, unless this amendment's adopted, the bill doesn't give the states the flexibility. The bill says, states, we know better than any of you. You have to take one size fits all. You must give the permit based on a weaker standard. So I strongly support the McNerney Amendment, and I appreciate what my colleagues have said in favor of the amendment.
Gentleman's time has expired. Anyone else seeking time? If not, the vote will occur on the amendment offered by the gentleman from California, Mr. McNerney. All those in favor say aye.
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 Those opposed, no. In the opinion of the chair, the no. Gentleman asked for a recorded vote. The clerk will call the roll.
Mr. Scalise. Mr. Hall. Mr. Hall votes no. Mr. Shimkus.
No.
Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Terry. Mr. Terry votes no. Mr. Burgess. Mr. Latta. Mr. Latta votes no. Mr. Cassidy. Mr. Cassidy votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Gardner. Mr. Gardner votes no. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Rush. Mr. McNerney. Mr. McNerney votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Barrow. Mr. Barrow votes no. Ms. Matsui. Ms. Matsui votes aye. Ms. Christensen. Ms. Castor. Mr. Waxman. Mr. Waxman votes aye. Mr. Whitfield.
The clerk will report. Oh, how Mr. Green?
Mr. Green votes aye.
Seeing other members, clerk will report.
Mr. Chairman, on that vote, there were 8 ayes and 14 nays.
The amendment is not agreed to. Are there any other amendments? Seeing none, the question now occurs on forwarding the discussion draft to the full committee as amended. All those in favor say aye. Those opposed, no.
No.
The ayes have it. Gentleman requests a roll call vote. The clerk will call the roll.
Mr. Scalise. Mr. Hall. Mr. Hall votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Terry. Mr. Terry votes aye. Mr. Burgess. Mr. Latta. Mr. Latta votes aye. Mr. Cassidy. Mr. Cassidy votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Gardner. Mr. Gardner votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Barton. Mr. Barton votes aye. Mr. Upton. Mr. Upton votes aye. Mr. Rush. Mr. McNerney. Mr. McNerney votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Engel. Mr. Engel votes no. Mr. Green. Ms. Capps. Ms. Capps votes no. Mr. Doyle. Mr. Barrow. Mr. Barrow votes aye. Ms. Matsui. Ms. Matsui votes no. Ms. Christensen. Ms. Castor. Mr. Waxman. Mr. Waxman votes no.
Any other members seeking recognition? One more coming. Mr. Green.
Mr. Green votes no.
Clerk will report when you count.
Mr. Chairman, on that vote, there were 14 ayes and 8 nays.
14 ayes, 8 nays. The ayes have it. The bill is agreed to. Without objection, staff is authorized to make technical and conforming changes to the legislation approved by the subcommittee today. So ordered. Without objection, the subcommittee stands adjourned.